My name's Adam. I'm with the City Attorney's Office, and I've been asked to give you guys a presentation on ethical rules as they apply to public employees. I will be working from a PowerPoint today, but feel free to stop me and ask questions. I want everyone in the room to understand what we go over. I will apologize. I'm recovering from a foot injury, so I'm going to be a little boring and stand probably within a 5-foot circle today. So the first thing that I want to get you guys to understand is, what do I mean by ethics? We're not talking about morals. We're not talking about good versus bad. We're not talking about right for wrong. What we're talking about is special rules that apply to city employees because city employees are paid with taxpayer dollars. So the topic is extremely boring until it's not. What I mean by that is you'll probably be bored by the topic today, but if a violation occurs, it won't be boring to you because you'll be either subject to employee discipline or your job and behavior will be in the media. And again, so when I say rules, these are actual laws developed by state lawmakers and our city council. So these are both state and local laws. I've combined them together for ease of application, but they come for both simultaneously. So why are ethics important? This is going to be a theme. First, criminal or civil violations can occur. You can be criminally convicted or be subject to civil dollars. You could be subject to employee discipline. You could be the topic of public opinion, media, and newspaper coverage. And most importantly, ethics are important because we need to maintain the public's trust with what we're doing with their money. So what are the rules? We, the city, believe that personal gain, either immediate or in the future secured by the misuse of one's position, is totally unethical. This is directly from the St. Paul Administrative Code, and this is language that our city council has drafted as kind of the policy document for what we deem is ethical and unethical as a city employee. And again, the underlying theme is our service needs to maintain the public's trust. We'll start with city contracts. No city official or employee shall knowingly be a party to or have a financial interest in any sale, lease, or contract with the city. Our administrative code defines financial interest to mean any interest that directly or indirectly results in any monetary or other material benefit. And it also includes financial gains to your spouse, dependents, or other persons who live within your home. So when you're dealing with a city contract, if you are going to have a financial interest in it, you cannot engage in that contract. There are a few exceptions to that rule. The most obvious is collective bargaining agreements. As city employees, the majority of our workforce is unionized, and your union may, on your behalf, contract with the city. Obviously, you have a financial gain in that. But other areas are licenses, zoning variances, street vacations, acquiring or granting easements, and the purchase of surplus city property and real estate, which must be done pursuant to state or local law. I call these the common examples of what you could do as a city employee or a city resident. Sorry, not a city employee, a city resident. Anything that your neighbor could do in carrying out the normal functions of, say, running their household or running their business, you can also do with the city as long as you're not treated specially. Another topic is private employment. City officials and employees cannot participate in any way in any contract, variance, real estate acquisition, or other governmental action that benefits their private employer. Employer is defined to include future employers if there is an agreement for future employment, and it means any work performed for money. So if you have a side job and your employer on your side job has interests or dealings with the city, you need to separate yourself from those interests. So if you work at the front counter of DSI and your outside employer comes in and applies for some sort of permit, you shouldn't be the one that is processing that permit application. You should pass it on to someone else. I want to highlight the fact that it talks about future employment. So even if you haven't received any monies from another employer, but you have agreed to do work for them, then you should also separate yourself. The whole principle behind this is no one should be getting special treatment because they are giving you employment. There should not be the perception that you are processing something or granting something to an outside company because you are also employed for them. So what should you do? We have a couple of examples that we'll walk through today, and this is the first. we'll always use Ellie the employee as our actor. So Ellie employee has a side painting business and wants to bid to paint over graffiti for the city. Is this a problem? I see some heads nodding, so I'll assume that's a yes. You are correct, that is a problem because Ellie employee would have a financial interest in that contract. Ellie cannot have a financial interest in contracts with the city as she is an employee. What should you do? The number one thing you should always do is immediately go to your supervisor if you believe you are approaching a situation that may involve the ethical codes, or you're approaching a situation where you just don't feel like where you feel like it may be suspicious. So number one, disclose it to your supervisor. If you do have a current contract with the city, we may be forced to terminate that contract. It is improper under both state and local law for you to have a contract and have a financial interest. Again, I said you'll see a theme today. A violation of this requirement is grounds for discipline, including termination, and there may be criminal consequences. I really am going to hammer that down today because I don't want anyone to face either unemployment or criminal consequences because they didn't understand our ethical code. Here's a few more examples. Ellie employee's painting business is applying for a zoning variance in order to operate out of her home. Is this a problem? No. Ellie can apply for any permit, license, variances, just like any other person doing business in the city of St. Paul. How about example 2? Ellie employee knows a person in DSI who can recommend approval of her variance application, and she gives that person a call. Is that a problem? Yes, potentially. If Ellie is looking for special treatment because she is an employee and she knows who to exploit to get that special treatment, that is a problem. Ellie should go through the process just like any other applicant, and there should be no special attention given. If your private employer is applying to the city for some kind of governmental action, 1, disclose it to your supervisor so someone else can handle it. You must not have any interaction with that transaction. Completely separate yourself from it. Even if it's something you believe that you're going to handle consistent with the way you would handle any other case, remove yourself so there is no appearance of impropriety. Just remove the whole appearance altogether. Again, a violation of this is grounds for discipline, including termination, and a violation is potentially a misdemeanor, so criminal consequences. Future employment. No official or employee shall represent a client or perform work for any other employer other than the City of St. Paul on any matter, project, or assignment in which the city is substantially interested, and one which the employee did any work within 6 months before leaving the city. So essentially, if you are working on a project within your last 6 months of employment with the city, and you go to your new job and that new employer wants you to work on the same project that the city had you working on, you're prohibited from doing that for an entire year. Again, this goes down to preventing an outside employer from getting a special advantage because of your knowledge or your expertise with city operations. They may offer employment or grant employment based upon that specialty knowledge, but again, if you worked on it in your last 6 months of employment with the city, you are prohibited from working on that project specifically for an entire year. If it's an unrelated project that wasn't in existence and you weren't working on in your final 6 months with the city, you can go ahead and work on that because ostensibly you don't have any specialized knowledge and you won't allow that employer to get a special benefit. But if it was something you worked on, you should not engage in that job. Offers of employment. This gets back to what I said. Some employers may try to gain an advantage by offering employment to city employees and get that specialized knowledge. A city employee must disclose any offer of employment made by anyone who has a financial interest in a matter, project, or assignment being worked on behalf of that employee. So if you are working on a job and an outside contractor approaches you to work for them on that project or approaches you to work for them regardless, you need to disclose that to your supervisor. Perhaps no action needs to be taken, and perhaps it's a completely legit offer and there's going to be no problems with it, but there may be problems and everyone should be aware. What should you do? If you do want to take a job and perform work on a project for which you worked on in the city, and the city is substantially interested, there is a small way that this can happen. The City Council, after a public hearing, can pass a resolution saying, 1, we consent to this work arrangement, and 2, that the public's interest and our ethical ordinances will not be affected. So again, this is for the City Council to decide, not an individual employee. So if you do want to pursue a outside employment opportunity, you think that doing so would be in violation of our administrative code pertaining to our ethical ordinances and rules, contact your supervisor and outline the facts for them. If the city deems that that's an appropriate relationship, the city council can, on your behalf, pass a resolution saying that that's okay. Again, a violation of this requirement is a misdemeanor, and if you do go and work for someone other than the city and they get some special benefit or special advantage and the city suffers a financial harm, you may be subject to a civil lawsuit and damages. What should you do? If you receive an offer of employment from any person with an interest in matter or project or assignment that you are working on, again, disclose it to your supervisor. The same theme, discipline, contemplated, misdemeanor, criminal consequences are involved. This is probably the most talked about topic with our ethical code, and it's employees being able to accept gifts. So no city employee shall knowingly receive any gift from a person or organization having business with the city, or where the gift would render or tend to render the employee susceptible to compromise or influence in any matter relating to his or her employment with the city. The city defines a gift as anything more than $50. And there is a special definition of local officials within our state statutory code that says that anyone involved in a decision or decision-making process could be a local official and should avoid accepting gifts. So I'll run through a couple of examples. One, gift is defined as something that is less than or more than $50, or if by accepting the gift you are compromising your employment with the city. So if you are working on, say, we'll go back to the example of the DSI counter person. If you are working the front counter at DSI, someone comes in and applies for a permit, and during the pendency of that application, they come by a couple days later and they give you a fruit basket for Christmas. If you are the ultimate decision maker on that matter, you should not accept that fruit basket. The outside public may believe that the only reason you process that permit or you process that application in a certain manner is because you received some sort of gift. And again, we just need to eliminate any appearance of impropriety. So don't accept gifts when people are have pending matters in front of the city, and that could compromise your decision-making ability. City employees cannot accept gifts, but the city can accept gifts. So if there are items which you would be receiving because you are employed with the city and it'll advantage the city or give the city an advantage, the city can accept that gift on your behalf. So if there is a training, say in Nashville, and you will gain expertise of that training and there's a scholarship offered, you can't personally accept that, but the city can accept that scholarship on your behalf, and the city can then send you to that training. That's completely appropriate. So employees should avoid accepting gifts. The city may accept those gifts on your behalf. All right, Ellie the employee. She works for Public Works, spends a lot of time with contractors, coordinating work. After several years, she's become close friends with several of them, and they often socialize together. One contractor invites Ellie and her family up north for a weekend together. Is that a problem for Ellie and her family to go? What do you think? No. Ellie is allowed to have friends. Ellie's allowed to socialize. Ellie can spend time with whoever she wants. The variation is, what if the contractor covers all associated costs? Now we have a problem. Now Ellie is accepting gifts from a contractor. That would violate our ethical code, and Ellie should not accept those gifts. So any employee can socialize with whoever they want. They can spend time with whoever they want, but if they are getting a material benefit or financial benefit from that relationship and that party has dealings with the city, they should avoid accepting those gifts or those material benefits. If you want to accept a gift and you're unsure about it, talk to your supervisor. There may be situations where you can accept gifts. Again, the definition of gift is things that are more than $50, so there are circumstances where your relationship with someone will not be affected because they give you something that is $50 or less. The one example or the one exception that I will say is every single department also has the ability to set their own definition of what is a gift. And I believe the Public Works Department has set that as $5 or more. So for the purposes of the people in this room, you can forget about the $50 benchmark. For you, you're allowed to accept gifts that are less than $5 unless accepting the gift would compromise your decision-making abilities. Number one, if you want to accept a gift, talk to your supervisor. They can give you the thumbs up or thumbs down. If you ask your supervisor and they give you the thumbs up, you no longer need to worry about it. You cannot be disciplined, or we will not discipline you for something that you are given the thumbs up to go ahead and do. If your supervisor doesn't know the answer, they will contact the city attorney's office and we can give advice. If you already took the gift, you may have to give it back. There are a couple of ways to resolve the issue if you have received a gift and you believe it's improper. One, you can contact the person that gave you the gift and merely give it back. Two, there is a process in our administrative code that outlines how you can give that gift to the city and kind of eliminate any issues with the fact that you've received the gift. Again, employees cannot receive gifts, individuals, but the city can receive gifts, so that takes care of that issue. In one of the previous trainings, someone asked me, well, can I just throw the gift away if I don't want to go through the hassle? Sure. If you throw the gift away, you have avoided receiving the gift and using the gift. But the problem I have with that is if someone believes that you accepted the gift, you now have no evidence that you threw it away. So it's your word against the trash cans. And if someone accuses you of spending a gift card that you were given or using something that was given, there is no documentation or evidence that you in fact returned that gift or turned that gift down. So if you do receive a gift, give it back to the giver or give it to the city, and both of those will eliminate any issues resolving around that gift. Again, the theme, a violation is grounds for discipline, including termination, and a violation could be a misdemeanor. So criminal consequences are contemplated. The use of city time. No employee or officer of the city shall, during the hours of employment, perform any service or do any work except for the city, and shall, during such hours, devote all efforts and time to the city. So the city of St. Paul employs you to do duties, and they pay you a paycheck to perform those duties. The money that makes up your paycheck originated with the St. Paul taxpayers, so they need to get the benefit of their bargain. They need to get the duties out of you and the performance out of you for which they are giving tax money to the city for. Ellie employee, as a part of her work for the city, drives to various job sites. One day during work, she runs to the pharmacy to pick up antibiotics for her sick child. It takes about 10 to 15 minutes. She does not do this during a break. Is this a problem? Yes, Ellie is running personal errands on city time. So essentially the taxpayers have just paid Ellie to go pick up a prescription for her child. That's not why the taxpayers are paying Ellie, so Ellie should not be doing that errand. Again, if you have permission from your supervisor, there are circumstances for which your supervisor may allow you to do certain things. If you are in a situation where you can spend 5 minutes during the workday to complete something and your supervisor says, go ahead and do that, you just add additional 5 minutes of work at the end of your day, that's fine. But again, that's all between you and your supervisor. You, the employee, don't get to make that decision. The city makes that decision for you. So again, make sure that during the work time for which you are being paid, you're dedicating your work to the city and performing city duties. If you are on the clock, you should be performing work on behalf of the city. City time is not your time, and again, a violation of this is grounds for discipline, including termination. The use of city property. City property are vehicles, computers, papers, and other office supplies and equipment. Essentially, city property is anything the city has purchased using taxpayer money. So any possessions of the city or any resources the city has are city property. It shall be unlawful for any person to use city property for a political purpose. We just had elections. There was a lot of campaigning going on. No employee shall use city property to advance the political agenda of anyone else. That includes the use of email, printers, paper, anything else. So if you are an employee for the city and your next door neighbor is running for, say, city council, you cannot email your colleagues and say, hey, this is my neighbor, here's why they'd be a good city council member. That is an improper use of city property. It shouldn't be used for any political purpose. Theft of public funds is a felony. So any misuse of property that could be deemed a theft could result in criminal consequences, which is a felony. And there is a mandatory report statute that dictates any employee who knows of theft of city property or theft of city funds be reported to the state auditor. So in your interactions or your day-to-day operations, if you know that some other city employee, say your colleague, is using a purchase card for their personal benefit, or they are dedicating city funds to some purpose that is not in advancing the city's interests and is improper, you do, as an employee of the City of St. Paul and a public employee within the state of Minnesota, have an obligation to report that violation to the state auditor. The state auditor can do an investigation to determine if that was an improper expenditure or purpose for which the money was put. There is a website that state auditors have for filing such claims. As an alternative, if you believe that someone that you work with or another city employee is misusing city funds, you can bring that to the attention of the city attorney's office, and we can file that claim or that report on your behalf. What should you do? The city just bought new lawnmowers, and the old ones are just sitting around and no one is using them. Ellie employee's lawnmower at home broke, and she has received a citation from the city because her grass is too long. Since no one is using them, Ellie took a lawnmower home to use. She did not get permission. Is this a problem? Yes. Ellie has converted city property into her own property. That is not why the City of St. Paul bought that piece of equipment. It is for Ellie's personal use, and that is improper. A little while ago, I talked about buying and selling city property. Ellie could, if she wanted, buy that surplus lawnmower off of the city. There is a state statute that outlines the process for which any person can buy old surplus equipment from any municipality. So if Ellie wanted to take advantage of that piece of equipment, she could have bought it from the city following the proper process, but Ellie cannot make that determination on her own. She cannot unilaterally take it home and put it to her use. Do not use city property for any personal or political purpose unless approved by your supervisor in advance. Again, this is another sub-theme. If you get permission to do something, you shouldn't fear any discipline or any consequences because you have given permission. Again, ask your supervisor. If you get a thumbs up, go ahead and do it. If they don't know the correct answer, they can consult with the city attorney's office so we can get the correct answer. A violation of this requirement is grounds for discipline, including termination, and again, depending on the circumstances, any theft of property or misuse of property could be a felony depending on the circumstances. Government Data Practices Act. The Minnesota Government Data Practices Act creates the presumption that all data in possession of the city is public data. Those are emails, phone records, timesheets, this document, the documents that you guys have in front of you right now. Anything that is created or maintained by the city in the course of its business is public data, and there is a presumption that any member of the public can come in, request it, and review it. There is one exception, or there are a number of exceptions, but the primary one is for personnel data. Things that are in your personnel file, certain items are private, so if you're a supervisor in this room, I don't want you to believe that everything that you are keeping on your employees is public. Those are private, but the presumption is that anything that the city has is public. The reason I bring this up is there are a tremendous amount of data that is generated by city employees, which I believe if they knew that they were going to be viewed by anyone outside of the city of St. Paul or outside of the communication for which they were communicating, they would be extremely embarrassed by it, and it could demonstrate that you're doing things improper. I have reviewed a number of email chains where I am dumbfounded by the content and the, for lack of better word, stupidity and the contents. So just be careful what you put in email. Another thing that I will add is because of our email system, drafts are saved for a certain period. So even be careful, even if you don't hit the send button, a draft email may also be retained and could be viewed by the public. Simple advice is if you think you might get in trouble, you probably will. If you receive an offer of any benefit or advantage because you are employed with the City of St. Paul and that benefit or advantage is not also readily available to any other member of the public, please do not accept it. You could be in violation of both state and local law. And when you are in doubt, ask your supervisor. Again, go seek clarification. I don't want someone to make their own determination that something is proper and learn later that it's not. I don't want anyone to suffer employment consequences or be the subject of a criminal investigation or criminal charges simply because they did not understand the ethical rules as they apply to them. And finally, this relates to our data practices. If you don't want to read about it in the newspaper, don't send it in an email. There are a number of resources out there on both state law regarding public official ethics as well as local ethical rules. One such resource is on the city attorney's website. I believe that this PowerPoint will be distributed to everyone. You can follow this link. We have an information guide that is, I would say, updated or republished about every 4 years. And it has a lot more detail than what I've covered today. So if you have questions and you want immediate clarification, feel free to go to that. But again, if you don't fully understand it or you are unsure, go to your supervisor or call the city attorney's office and we can give you advice.